So in Minnesota, there are actually three different types of probates. There is informal probate, and then there's formal unsupervised probate, and then there's formal supervised probate. It's really important that you open probate in the correct type of probate. Informal probate is reserved for very straightforward situations. You don't want to have any complicating circumstances. There needs to be no ambiguities in the will that need to be resolved. So oftentimes, informal probate is reserved for probates that are small and straightforward and have adult beneficiaries. So formal supervised is oftentimes reserved for situations where maybe there's real estate that needs to be sold in the estate, maybe there's minor beneficiaries. Those are all things that might kick it into formal supervised. In this circumstance, there is a court hearing that appoints the personal representative to act on the estate. Okay. And then the third type of probate is the most formal. It's called the formal supervised. And this can happen in many different situations that are more complex. So for example, let's say the estate is insolvent, meaning the debts are bigger than the assets of the estate. That's something that will kick the probate into formal supervised. When you have a formal supervised probate, it means that the court will be supervising it even after the opening. So later on, when you go to sell property or close the administration, there's going to be further court hearings. So if there isn't the complicating factors, most people will oftentimes prefer to go formal unsupervised or informal probate.